Hello guys, welcome back to another video. So today with the help of this video we are going to share with you 6 cases from across history which are still shape the law today. You might not have heard this video before then, and because this is a very information that we contain for you which is very useful according to modern time and in ancient times. What are the types of the cases along with their facts which are going to share with you today in this vlog. So friends, if you have not subscribed my channel or a new viewer first time coming on my channel, so please subscribe my channel so that you will get all the new updates, and don't forget to press the bell icon. So let's start this video and see what are the most important cases from across history which still shape the law today. The first one is of the case of proclamations 1610. You may know that over 400 years ago, the Chief Justice, Sir Edward Coke, who is also the prominent jurist, belongs to the England, ruled that King James I could not prohibit new building in London without the support of Parliament. King James believed that he had a divine right to make any laws that he wished, but the court opposed his view and decided that the monarchy could not wield its power in the arbitrary way. By the end of that century, it laid the foundation for today's constitutional supremacy, whereby no matter who is the king or queen must respect the law-making authority of the elected parliament. Second most important case is of ENTICK versus CARRINGTON, which is held in the year 1765. Author and schoolmaster John ENTICK was suspected of writing a libelous pamphlet against the government. In response, the Secretary of State St. Nathan Carrington, who was a royal servant, along with a group of other king's men, to search ENTICK's house for evidence. ENTICK then sued the men for trespass. The court decided that the Secretary of State and did not have the legal authority to issue a search warrant, and therefore Carrington had trespassed. This case gave rise to the principle that no man is above the law, which is practicing till date. Not even the Secretary of the State. To this day, law enforcement agencies around the world may only do what the law allows. This is one of the very important case, DONOGHUE and STEVENSON 1932. In this case, which originated in Scotland, Mrs. Donoghue was given a bottle of ginger beer which allegedly contained the decomposed remains of a snail. She claimed to have suffered shock and gastroenteritis as a result, but as she had not bought the drink herself, she had no contract on which to sue. This later became a landmark court decision as it laid the foundation of the modern law of negligence, establishing general principles of the duty of care, which in general times and in today's times covers under the law of torts. Next important case is of FAGAN versus Metropolitan Police Commissioner 1969. To be guilty of a criminal offence, there often needs to be an unlawful act accompanied by a guilty state of mind, such as a criminal intent. So, having accidentally driving his car onto a policeman's foot, did Mr. Fagan commit an assault when he decided not to remove it? Surprisingly, Mr. Fagan suggested not because he had no criminal intent at the time the car first went onto the foot, but the court in this case held that the deciding to leave the car there was a combination of act and intention, which meant he was guilty of the offence. Another important case is of R versus R 1991. The law is constantly evolving to meet changing social attitudes. In this case, the House of Lords swept away the common law rule that a man could not be guilty of raping his wife. The previous rule was based on a 1736 pronouncement which provides that by their mutual matrimonial consent and the contract, the wife had given herself up to her husband, consent which she cannot retract. So by their mutual matrimonial consent and contract, the wife had given herself up to her husband consent which she cannot retract, and in this case the House of Lords ruled that for modern times marriage is a partnership of equals and any other suggestion was quite unacceptable. Another important case is of CARLILL versus CARBOLIC Smoke Ball and Company, which is generally based on the law of contract. Mrs. CARLILL sued the manufacturer of the carbolic smoke ball, which is a device for preventing colds and flu, which had promised a reward of £100 for anyone catching flu following the use of its product, but then refused to pay out. The court then decided that this promise, together with Mrs. Carlill's use of the product as directed, amounted to a legally binding contract and she was entitled to the reward. The case explores many of the principles that must be present in modern time contracts, such as offer and acceptance, which is the very basis of the law of contract as the Indian Contract 1872 as well. Before we can make legally enforceable agreements between each other, yet this most famous of cases may never have been brought at all had Mrs. Carlyle not been married to a solicitor. These were the most important cases which still known according to their formulated principles, which is governed under the various law of contract, law of evidence and the law of torts as well. So friends, if you like this video, please don't forget to subscribe my channel and press the bell icon as well, so that you will get all the new upcoming updates of the videos as and when it is uploaded on my channel. Thanks for watching this video and see you soon with a new another daily video topics.